Hi all, welcome to Mentors. As part of CLAT Nation 2026, today we are discussing legal reasoning. As part of legal reasoning, today the topic is arranged based on Indian polity and constitution. I am Advocate Shahnaz. Welcome again to the class. So before moving to the topic, let me tell you one thing. Our class is scheduled like, first we will be discussing about the basic concepts of India's constitution. It's is given as an introduction to India's constitution, like what is India's constitution, who framed India's constitution, and the details about and the history of the making of India's constitution, and the sources of major sources of India's constitution, and the very basic things about the formation of India's constitution. Those basic principles or those basic details will be given at first, and after that, after being thorough with such basic points, we will be discussing question and answers. Questions are arranged in the form of reading comprehension passages and questions based on such paragraphs. So, after clearing these basic concepts, we will be moving to paragraphs and questions based on those. Okay, welcome once again. Let's move to the basic principles or basic ideas of India's constitution. Let's move into the slide. Yes, you know that we have too many laws in our country, like criminal laws like BNS, BNSS, BSA, like that we have too many criminal laws, and we have civil laws, Civil Procedure Code and other Contract Act, many civil laws and family laws and many other statutes and acts. Above all, we have our constitution. It's also a statute. We have our constitution. So among all these laws, which is the basic law of our land? Your answer should be India's constitution. So India's constitution is the basic law of our country. So among all these laws, we have a basic law, that is the very law of the land, that is our India's constitution. So our first point is that India's constitution is India's basic law or law of the land. Why India's constitution is told as basic law? Because according to India's constitution, the country has been running, or every governance, rights of the people, duties of the people, citizenship, everything is decided, and everything is formulated. The Supreme Court or court structure, judiciary, executive, legislature, everything is functioning based on based on India's constitution. Okay, so the first point is India's constitution is the basic law of our country, basic law of our country. It is also known as the law of our land, and it is also supreme law of our country. Constitution is also supreme law of our country. Among all the other laws, which is the supreme, which is the basic, which is the higher, that is India's constitution. So when there is a conflict with any other laws with that of constitution, which will prevail, the constitution will prevail, because it is the basic law as well as the supreme law of our country. So we have studied 2 points. India's constitution is India's basic law, law of the land, and also it is the supreme law of our country. Okay, then our next point is how India's constitution is seen. That is our next point. It is seen in the written format. India's constitution is seen in the written format. In the world, we have unwritten formats of constitutions, like Britain has unwritten format for their constitution. That means it is not codified as our constitution is codified. India's constitution, USA's constitution, everything is examples of written constitution. So we have written constitution. Our constitution is one of the lengthiest written constitution of the world, whereas America's constitution is shortest written constitution of the world. So India and America have written kind of constitution, whereas Britain has unwritten format constitution. That means their constitution is not codified. Okay, that is our second point. Okay, our next point is whether India's constitution is easy to amend or not. So, our point is India's constitution is neither rigid nor flexible. What do you mean by rigid? Rigid means very hard to change, and flexible means very easy to change. So, is India's constitution very easy to change? No. Is very hard to change? No. We have a blend of both the rigidity and flexibility, or we can say that India's constitution is neither rigid nor flexible. Some parts of India's constitution can be amended easily. Some other parts of India's constitution cannot be amended easily. That is our next point. So, India's constitution is a blend of both the rigidity and flexibility. Yes, that means some articles or some parts or some areas of India's constitution can be amended easily and some others cannot be amended easily. So, that's why we are saying that India's constitution is a blend of both the rigidity and flexibility. Okay, then our next point is who framed India's constitution? India's constitution was framed by the Constituent Assembly. Constituent Assembly is was a body of people. They were both elected people. There were both elected people and nominated members, and it is a house like our parliament, like our legislatures. It was a house of people. They were either directly elected or they were nominated. Okay, our next point is who framed India's constitution? So, the answer is the Constituent Assembly. So, Constituent Assembly was a house consisting of too many people. They actually framed India's constitution. So, we had to discuss after this about the history of the constitution making and the history of the Constituent Assembly. So, one word question is who framed India's constitution? The India's constitution was framed by the Constituent Assembly is our answer. So, in Constituent Assembly, there were 389 members, and when it was actually formed in the year 1946. And in the year of 1947, when India got independence, there was another thing that happened in India was the partition of India into India and Pakistan. So, after the partition of India and Pakistan, the strength of the Constituent Assembly was reduced to 299. That is from 389 to 299. That all things we will be discussing later. So, totally the Constituent Assembly was consisting of 389 members, and this Constituent Assembly includes the members, they are both elected and nominated members, and they actually framed India's constitution is our point. And who is known as the father or architect of India's constitution is our next point. So, who is known as India's constitution's father or architect? That is Dr. B.R. Ambedkar. We all know Dr. B.R. Ambedkar. Dr. B.R. Ambedkar is known as the father of India's constitution or architect of India's constitution. He was the first law minister of independent India. He was the chairman of the drafting committee of the Constituent Assembly. Constituent Assembly had too many committees and major and minor committees. Among those committees, the one of the important committee was the drafting committee. Their duty was to draft India's constitution. That was headed by Dr. B.R. Ambedkar. That's why he is known as the father or architect of India's constitution. And also he was the first law minister, and he has too many contributions to India's polity and constitution that we will be discussing later. Okay. Then our next point is who is known as the protector of India's constitution? Who is known as the protector of India's constitution? That is Supreme Court. So, we have very independent judiciary in India. Our judicial structure is like that. At the apex or at the top we have Supreme Court, and below that we have high courts. In India we have 25 high courts now, and below that there is district judiciary, then sessions, and it is divided like sessions and like that, and below that there is municipal magistrate according to their nature, so whether it is civil or criminal, like that. That is our judicial structure. And so, at the top of this judicial hierarchy or judicial structure, we have our Supreme Court. This Supreme Court is known as the protector of India's constitution. India's constitution's protector is known as Supreme Court. Supreme Court is known in that name. Okay, Supreme Court is the apex court of India. It is the highest court of India. Okay, our next point is, this is something related to the history of Constituent Assembly or the history of making of the constitution. The point is that the idea of a Constituent Assembly was put forward for the first time by whom? By whom? M.N. Roy. So, M.N. Roy put forward the idea of a Constituent Assembly for the first time in the year 1934. 1934. In the newspaper Indian Patriot, he put forward the idea of a Constituent Assembly for an India. You might be knowing that in 1934 we were under the British rule. So, we were not got independence or freedom. So, we were under the British rule. At that time, in a newspaper called Indian Patriot, M.N. Roy, who was a communist leader then, demanded or put forward the idea of a Constituent Assembly for the making of a constitution for an independent India. Okay, that demand was accepted or supported by the Indian National Congress later in the very coming year, and they also demanded for the same, and there were August offer by British Parliament. After that, Cripps mission was in the year 1942, and after that a cabinet mission came to India in the year 1946. Thus, that cabinet mission paved way for the formation of a Constituent Assembly. This is the history of making of a Constituent Assembly, and that Constituent Assembly by taking 2 years, 11 months and 18 days framed India's constitution, and on 1950 January 26, India's constitution came into enforce. This is a very light history or timeline of the making of India's constitution. We will be discussing it very detailedly in the coming classes or this class itself in the next session. Okay. So, our point was the idea of a Constituent Assembly was put forward by whom? M.N. Roy in the year 1934. So, after that our next point is which commission paved way for the formation of a Constituent Assembly. That I have already told you, that is Cabinet Mission Plan. Cabinet Mission Plan of the year 1946. So, what was this Cabinet Mission Plan? Cabinet Mission Plan was a 3-member body commission or a mission. All the 3 members were the ministers of the British cabinet, British parliaments or British cabinet. They came to India to study about the feasibility of making a constitution for India with other similar matters. So, this cabinet mission came to India in the year 1946, and they studied about the possibility of making a constitution for India, and for that purpose for making a Constituent Assembly for India, and they went back the same year and submitted a report before the British Parliament, and that was positive. Based on that report, the British Parliament decided to constitute a Constituent Assembly for India for the making of a constitution. Okay. So, this cabinet mission had 3 members, and their names are Pethick Lawrence, A.V. Alexander and Stafford Cripps. Okay, Pethick Lawrence was the head of this cabinet mission plan. This mission was a success. They had many other aims also. One of the important aim of this mission was to study about the possibility of making of a constitution and a Constituent Assembly. Okay. So, which mission or which committee led to the formation of India's constitution? If such a question is asked, that the answer is Cabinet Mission Plan of 1946. Okay, then our next point is the formation of Constituent Assembly. When did Constituent Assembly form? It was on 1946, the very same year of the Cabinet Mission Plan. 1946 December 6. So, on 1946 December 6, the Constituent Assembly of India was framed for the making of constitution for India. Okay, let's move to next slide. Okay, our next point is when did first meeting of the Constituent Assembly was happened? The first meeting of the Constituent Assembly was on the very same year, 1946 December 9. First meeting of the Constituent Assembly was held, and here important point we have to remember is that Dr. Sachidananda Sinha was selected as the temporary president. temporary president of the Constituent Assembly on that date. Temporary president of or provisional president of Constituent Assembly on the meeting on the first meeting held on 9th December 1946. That was the peculiarity of that meeting. It was the first meeting. After that, the second peculiarity is that temporary president was selected on that meeting. That was Sachidananda Sinha. That was a French practice actually. He was the oldest member of that assembly. That's why he was selected as the temporary or provisional president of that assembly. Okay, then on the next meeting, which was held on 11th December, they were held 11th December 1946. Everything is happening on the same year with the difference of 1 or 2 days. Okay, here the 11th December 1946. On that meeting, election to the Constituent Assembly was held. So, in that election, Dr. Rajendra Prasad was elected as the permanent president of the Constituent Assembly. So, Dr. Rajendra Prasad was elected as the permanent president of the Constituent Assembly on the meeting and the election held on 11th December 1946. That was the peculiarity of that date. So, that is important. So, who is the permanent or the president of the Constituent Assembly? Dr. Rajendra Prasad. Then, who was the temporary president? That was Dr. Sachidananda Sinha. Okay. Next it is on December 13, 1946, Jawaharlal Nehru presented objective resolution before the Constituent Assembly. Jawaharlal Nehru presented objective resolution. Objective resolution is the philosophy of India, independent India. That was presented by Jawaharlal Nehru before the Constituent Assembly on 13th December 1946. And now this objective resolution seen in the form of preamble in our constitution. So, it is actually the objective resolution is known as a predecessor to preamble of India's constitution. That's why Jawaharlal Nehru is known as the architect of preamble of India's constitution. Nehru is known in the name architect of preamble of India's constitution. The reason is that he actually presented the objective resolution now seen in the form of preamble. Okay, I am dealing with something about Jawaharlal Nehru. You all know he was the first Prime Minister of India, and all related facts you may know. So, I am moving to next point. So, this is the date of 1949, November 26. What was so peculiar? It was on this date India's constitution was adopted by the Constituent Assembly. Constituent Assembly framed for the formation of a constitution, and constitution they prepared the constitution and they themselves adopted India's constitution, and they the date of adoption is 1949 November 26. Constitution that for remembering the date of adoption of India's constitution, it is now celebrated as National Constitution Day or National Legal Day in India. Okay, it was on this date India's constitution was adopted by India's Constituent Assembly, and India's constitution came into force or commenced on a later date correctly after 2 months, that is 1950 January 26. Constitution commenced or came into force, enforced. And to remember that day, we celebrate every January 26 as India's Republic Day. So, these two dates are very important. November 26, 1949, it was on that date Constitution was adopted by Constituent Assembly. That means it was officially accepted by the Constituent Assembly as India's Constitution. And the second date is January 26, 1950. It was on that date that adopted Constitution actually came into force. That was on January 26. January 26 is Republic Day. November 26 is Constitutional Day or Legal Day in India. You know what is republic? That's also important. Republic means a state or head of the state is either directly or indirectly elected by the people. Such a state is known as republic. India became republic. India's head of the state is India's president. He is indirectly elected by the people. So, India is a republic. India became republic by the coming of the constitution. That's by the day in which a constitution came into enforced is known as India's Republic Day. Okay. So our next point is, who is known as the or who was the legal advisor of India's constitution? The legal advisor was B.N. Rao. B.N. Rao was the legal advisor of Constituent Assembly or India's constitution making. Okay, our next then I am talking very miscellaneous too many points that may be helpful for you for your understanding the concept behind the making of constitution and etc. Then when our India's constitution came into enforce on 26th January 1950, at that time we had one preamble, 22 parts to our constitution, 395 articles to our constitution and 8 schedules to our constitution. So at the time of its introduction or its commencement, we had 22 parts, 395 articles, 8 schedules and 1 preamble for our constitution. And as of now, we are talking in 2025, the number of articles, schedules and parts has enhanced or increased. Now we have 25 parts in our constitution, about 470 articles we have and 12 schedules we have. So previously we had 8 schedules, now we have 12 schedules. Previously we had 395 articles, now we have about 470 articles. And previously we had 22 parts, now we have 25 parts, and then we had a preamble, now also we have the preamble. Okay, now I am moving to the next slide. Our next point is about drafting committee. As I have already told you, the chairperson of the drafting committee was Dr. B.R. Ambedkar. Dr. B.R. Ambedkar is known as the father or architect of India's constitution. He was the head or chairman or chairperson of the drafting committee. This drafting committee actually drafted the constitution. So a drafting committee was formed on 29th August 1947. This date is important. August 29, 1947. It was on this date the drafting committee was formed. So drafting committee was a committee inside the India's Constituent Assembly. So drafting committee had 7 members including the chairman. The chairman was Dr. B.R. Ambedkar. The other members like K.A. Munshi, Muhammad Sadullah, etc. etc. So our point is, head of the or chairperson of the drafting committee was Dr. B.R. Ambedkar. They actually drafted India's constitution, and the committee was formed on 49 August 29. After completing each draft test, they published it in the local and other newspapers in India. They accepted the public opinions from the people and then redrafted, and like that, that much efforts and process India's constitution was framed. Okay, our next point is, how many days does this Constituent Assembly took for the making of India's constitution? That is 2 years, 11 months and 18 days. About 3 years actually, but we need exact number. 2 years, 11 months and 18 days are the time duration that has been taken by the Constituent Assembly for the making of India's constitution. Next point. The total membership that I have already told you. The total membership of India's Constituent Assembly was 389. It included both elected and nominated members. Among the 389, there had 296 members from the British Indian provinces. So at that time, it is a number of the year 1946. In the year 1946, India was not independent. India was under the colonial rule of British Parliament. At that time, we formed our India's Constituent Assembly, and the Constituent Assembly included 389 members. It included members from British Indian provinces and Indian princely states. 93 members from the Indian princely states. So total 296 plus 93, that is 389 members was the total membership of the Constituent Assembly at the time of formation. In the year 1946, this was the total membership of India's Constituent Assembly. So after partition, that I have already discussed with you, in the year 1947, along with the independence of India, India was divided into India and Pakistan. In that year, the total membership of the Constituent Assembly also reduced. Some members went to along with Pakistan. So the total membership was reduced from 389 to 299. So after 1947, the partition, the total membership of Constituent Assembly, India's Constituent Assembly was reduced to 299. That also you have to remember. Then our next point is, who called India's constitution as quasi-federal? Quasi-federal means half federal, or the elements of federalism and unitary. So who called India's constitution is quasi-federal? Who called quasi-federal? K.C. Weir called India's constitution as quasi-federal. There are many elements of federalism in India, but the state India is not fully federal. There are elements of federalism like a division of power between central and state, etc. But there are some features of unitariness also with India. So India is not fully federal. It is federal in form. Otherwise, it is known like Indian constitution is or India is federal in form and unitary in spirit. Its spirit is in unitary, but it is in the seed in the form of federal. Okay, that is our next point. The K.C. Weir is important. And next point is, who called India's constitution cooperative federalism? Cooperative federalism that was called by Granville Austin. Granville Austin called India's constitution as cooperative federalism. Okay, these all are miscellaneous points about constitution and some features of it. Okay, now we are moving to the sources of India's constitution. Actually, India's constitution derived from many sources, from the people of India, from the life of Indian people, and also many of the important ideologies and concepts are taken from foreign countries or the other countries of the world, their constitution. So, here mainly we are discussing about the borrowed principles or concepts of India's constitution, that is actually from the other countries of the world. So, sources of India's constitution. Before going to other countries of the world, firstly we are discussing the ideologies or the principles or the concept that we have actually taken from the Government of India Act 1935. So, mainly 4 points we had to look into. First one is office of the governor. The post of governor, now also we have a post of governor that was actually taken into India's constitution from the Government of India Act 1935. You may all known about the or heard about the Government of India Act 1935. Britishers ruled India through many acts and statutes that was actually passed by British Parliament. It was one among the latest acts brought by Britishers into India, Government of India Act 1935. So, in that act, many principles or many ideas we took from that act to India's constitution that we even now following. So, first thing is office of the governor, that was actually took from that, and emergency provisions. Emergency provisions means there are 3 kinds of emergencies mentioned in our constitution, that is national emergency, state emergency and financial emergency. These emergency provisions, when there is an emergency, our state will become, federalism will be cancelled and our state will become unitary, and these emergency provisions are taken from the 1935 Act of Government of India Act. Okay. Then third thing is PSC, Public Service Commission. Public Service Commission is a platform for conducting, or an agency, recruitment agency for conducting exams and recruitment to the central government or concerned state governments. So, these Public Service Commission models were actually introduced here by the Britishers, and this idea was actually taken from the Government of India Act 1935. There is also one more point, that is federal judiciary. Federal judiciary. That means the we have already discussed about the structure or strata or hierarchy of the judiciary in India. At the top we have Supreme Court, that I have already told you. At the top we have Supreme Court, below that we have High Courts, and below that we have district judiciary, then criminal, civil, like that it is further divided. So, in this hierarchy, there is actually a division of power between each strata of judiciary. So that is actually, and there is buying and giving between the judiciary. There is appeals going to higher courts, and there is some orders that is binding on the lower courts passed by the higher courts. So there is and giving and buying between the judiciary. So this is the actually federal judiciary concept. This concept we still following in our constitution, that was actually taken from the Government of India Act 1935. That is the fourth point. So we have completed the first source of our constitution. Government of India, and also one more point, Government of India Act 1935 is otherwise called in some other competitive exams like India's constitution has most profound influence from what? And we may think that it is from the British constitution or from the America's constitution, and the answer is always given as India's constitution has most profound influence on Government of India Act 1935. Okay, now the ideas taken from Britain. So we have already discussed one point about British constitution, that was Britain does not have a written constitution. They follow an unwritten format constitution. That is, their constitution is not codified. That point we have already discussed. So now we are moving to the principles or concept that we have took from the British constitution. First thing is that parliamentary form of government. India has a parliamentary form of government. That means actually we have two heads in our country. One is the head of the government, that is the prime minister, and the other side we have the head of the state, who is the de jure head or the nominal head of our state, that is president. Prime minister is the real head, he is the head of the government, and he is the real head. Okay, this kind of parliamentary form we have been following, and all the executive actions in our country are taken in the name or known in the name of India's president, who is the executive head of our state, whereas the actual power lays with the real head or the head of the government, that is the prime minister. So this kind of a parliamentary form of government we are following, that actually the idea took from the British constitution. In Britain they don't have a president, instead they have a king or queen, whereas we have president in India. The prime minister, post of the prime minister in India is similar to that of Britain. So Westminster model or parliamentary form of government model of Britain that we are following now in India. Then office of the prime minister, the post of prime minister and the office of the prime minister is took from the British constitution. The cabinet system, we are following the cabinet system modeling the British constitution. Bicameralism. Bicameralism means, by means two, our legislature has two houses actually, Lok Sabha and Rajya Sabha. Lok Sabha and Rajya Sabha. So that is our bicameral legislature. In many of the states, most of the states we follow unicameralism. In our states, in Kerala we have unicameralism. Many of the states we have unicameralism, but like states like Karnataka and other five more states, they are following bicameralism. In India we have bicameralism. In 6 states also we are following bicameralism, but in most of the states we are following unicameralism when it comes to states. So the concept of bicameralism was actually taken from the British constitution. That means the legislature has two houses, two sabhas. The next is Speaker of Lok Sabha. Lok Sabha is the lower house or house of people. The people are directly elected to that sabha or that house, and the speaker means the presiding officer of Lok Sabha. The office of the Lok Sabha speaker was created, or the idea was brought to India based on British constitution. Next one is CAG. CAG means Controller and Auditor General. Controller and Auditor General. He is the head of the India's Accounts and Audit Department. He is doing the all the audit and accounts matters relating to both the central and the state governments. So this post was created based on British constitution. Next is very important, rule of law. Rule of law means the basic concept of our law. That means we have equality principle, that is equality before law and equal protection of law is the rule of law of India. Basically, Article 14 of India's constitution as part of part 3 and fundamental rights, we may have been studying that. Equality principle, equality before law and equal protection of law, that is our rule of law. Lord Dicey is known as the proponent of this rule of law concept. Actually the concept evolved or derived or emerged in Britain. Okay. So, India's rule of law is equality before law and equal protection of law. Equality before law principle also we took from the British constitution, but the equal protection before law is the principle that we actually took from the American constitution. Okay. The next point is single citizenship. In India, we have single citizenship. We follow only single citizenship, that is a citizenship granted by the country or the nation. We don't have any citizenship provided by a state, a concerned state. We don't have any citizenship provided by UP or Kerala or Tamil Nadu or like that. We have only one citizenship that is given by India government. So, citizenship in countries like America, they are providing double citizenship, but we don't follow that. So, we are modeling British constitution for single citizenship. Next is writ. Writ is a legal order given by a court of law, that is especially Supreme Court or High Court, when there is infringement to fundamental rights or legal rights of the people, the higher courts issuing this writ jurisdiction. Okay. These all are the ideals or points or ideas we took actually from the British constitution. Then we are moving to the points we have taken from America's constitution. So basically the format of India's constitution was chosen based on based on American constitution. That is, the very format is written format. India's constitution is seen in the written format. That format itself we took from the American constitution. American constitution also I have already told, seen in the written format. That is the shortest written constitution of world, whereas India's constitution is one of the lengthiest written constitution of the world. So written format is took from American constitution. Then other point is preamble of India's constitution. We have a preamble as an introduction to India's constitution. That preamble concept we have actually took from America's constitution. So, I have already told one point about preamble. The objective resolution we have already studied. The objective resolution presented by Jawaharlal Nehru on 13 December 1946 is known as the predecessor to preamble. That is the idea, that means the ideals included in the preamble. Now we are talking about the idea of making a preamble that we actually took from the American constitution. Then fundamental rights. In America they have Bill of Rights. We took that idea into India and implemented or make as fundamental rights. We have 6 fundamental rights. That is the very basic rights of every people of India. Next is independent judiciary. As we have already studied, we have a very independent judiciary. Judiciary should be independent. It should be separated from legislature and executive, that as the other wings of government or state. Judiciary should be independent. Then only we will there will be having justice. The next point is that we actually took from American constitution is impeachment of president. Most of the points relating to the post of president is actually took from America, because America is known for the presidential model of ruling. So impeachment of president means removal of president from his post. That actually we took from the Constitution of America. Then Supreme Court. Many things related to Supreme Court. Many things related to Supreme Court are actually took from American Constitution. Then judicial review. Judicial review is the power of judiciary to review the legislations made by the parliament or other legislatures. So this power is also we took from the American Constitution. These are the points we took from the America's Constitution. Okay, now about Ireland. From Ireland, we took directive principles of state policy, that is actually dealt in part 4 of India's constitution. Directive principles are the directions to the policy makers of India given by the constitution makers. Next, the method of election of president. Method of election of president. Method of election of president is, president's election is not direct election. President is elected by an electoral college consisting of so and so members, that we will be discussing later. So the method of president's election is actually, president is elected by that electoral college by way of proportional representation system. That is a different system. So that actually we took from the Constitution of Ireland. The third point, President nominates members of Rajya Sabha. President nominates 12 members to Rajya Sabha, you may know. They are from known for literature, art or economics or something like that. Such eminent personalities are nominated by President to Rajya Sabha. The actual nomination number is 12. So President nominates members to Rajya Sabha, is that provision is actually we took from the Ireland constitution. Then next is France. From the constitution of France, we took actually the ideals of liberty, equality, fraternity. These 3 points, liberty, equality and fraternity, was actually came as part of the French Revolution of 1789. So, as part of French Revolution, these two terminologies derived and that became part of France's constitution, French constitution. So from French constitution, we took these ideas of liberty. Liberty means independence or freedom. Equality, you may all know. Fraternity is a kind of brotherhood. So these ideals are took from the constitution of France, and also republic. I have already explained what is republic. So the idea of republic is also taken from the constitution of France. The next is South Africa's constitution. We took the amendment procedure of India's constitution. Article 368 of India's constitution dealing with the amendment of India's constitution. Amendment means making changes to India's constitution. So India's constitution can be changed. As for now, we have amended 106 times India's constitution. So amendment nature or the provisions relating to amendment we actually took from the constitution of South Africa. The next thing is election of Rajya Sabha members. Election to Rajya Sabha. Rajya Sabha election is not like election of Lok Sabha. Lok Sabha election is is a direct election. People are directly electing the Lok Sabha members, but Rajya Sabha members are not directly elected by the people. They are indirectly elected by the people. They are actually elected by the legislative members of each state. So, election of Rajya Sabha members and amendment of India's constitution. These two provisions or principles we took from the constitution of South Africa. Okay, now about Canada. The points or principles provisions we took from Canada. First thing is federal system. Federal system means division of power between a central government and state governments. India follow the elements of federal system. It's actually federation with a strong center, the concept is. So, we follow the elements of federation, and part of this there is union list, state list, etc. in the 7th schedule of India's constitution. Union list means there are certain subjects in the list that in that subjects the union government has to make a legislation. State list means certain subjects that is included in the state list in which the concerned state governments are making legislations. So, these all lists, union list, state list, and there is also concurrent list. These lists are seen as part of the federalism concept. So, these all are took from the Constitution of Canada. And there is residuary powers also. Residuary powers means rest of the powers. That means the subjects not included either in a union list, state list or concurrent list. That is included in, rest of the powers are included in the residuary powers. For example, cyber law, that was a later concept compared to the coming of the constitution. So, residuary powers, matters included in the residuary powers are like cyber laws, and central government or the union government has authority over the list is included in the residuary powers. So, federal system, union list, state list, residuary powers. These all concepts we took from the Constitution of Canada, and when we are coming to Australia, we took the idea of concurrent list. Concurrent list also included in the 7th schedule. Concurrent list means both the central government and the state government has authority to make legislation in the subjects included in the concurrent list. For example, education is an example for concurrent list. So that both the central government and state governments can make legislations, policy, etc. in the matters included in the concurrent list. So that we took from the Constitution of Australia. The next point we took from Australia is joint sitting of Parliament. It is dealt in Article 108 of India's Constitution. Joint sitting of Parliament. Sometimes for passing any legislations, our two houses of our legislature, union legislature, that is Lok Sabha and Rajya Sabha, sit together and they pass the legislations or they discuss things. Such sitting is known as joint session or joint sitting of Parliament. Such a joint sitting are called by India's President and presided by Speaker of Lok Sabha, you may all know. Then this all we took from the Constitution of Australia. Next, Germany. From Germany, we took the idea of suspension of fundamental right during national emergency. When there is a national emergency in India based on war, external aggression or internal rebellion, our fundamental rights will get suspended. That suspension of fundamental right principle we actually took from the Constitution of Weimar or German Constitution. And lastly, the principle we took from the Japanese Constitution is procedure established by law. Procedure established by law is a concept dealt in Article 21 of India's Constitution. Article 21 is right to life and personal liberty, privacy, etc. So, as part of that, procedure established by law has to be followed when state is making restriction on Article 21. In that aspect, that term procedure established by law is discussed in Article 21 that we actually took from the Constitution of Japan. Okay, now the introduction part is over. Hope you all understood it well. We could not include all the points here, but I tried my level best to include most of the areas here. Okay, now we will be moving to the reading comprehension area. There we will be having paragraphs based on this introduction, and rest of the areas we could not cover. So after reading the paragraphs, we will be discussing questions and answers. You have to say the answers and all. So moving for that session. So our first paragraph is, yes, hope you can also read with me. So, what is the Constitution? It is a supreme law of the country which is not only defines the framework of basic political principles but also outlines the structure, powers and functions of various government institutions. It includes the fundamental rights, directory principles of state, policy and fundamental duties of citizen. Notably, the Indian Constitution is the longest written constitution in the world. Importantly, Parliament cannot override Constitution since it was created by a special Constituent Assembly. Although the Constitution came into force on January 26, 1950, the idea of a Constituent Assembly was first proposed in 1934 by M.N. Roy, a Communist Party leader. This demand was later taken up by the Indian National Congress and formally accepted by the British government in 1940 through the August Offer, which granted Indians the right to draft their own constitution. In 1946, elections to the Constituent Assembly were held. Out of 296 seats, the Congress won 208 and the Muslim League 73. The Constituent Assembly for the Undivided India met for the first time on December 9, 1946. A drafting committee was formed on August 29, 1947 with Dr. B.R. Ambedkar as the chairman. The draft constitution was completed on 26 November 1949, a date now celebrated as Constitution Day or National Law Day. So, this extract is taken from Celebrate the Supreme Law, an article written by R. Kritika, published in the Hindu Daily. Okay, this is our paragraph. From this paragraph, we had to answer the coming or following questions. Hope you understood the paragraph well. It's due to limitation of time, I am showing that a very little bit time. You can repeat it by saying. The first question is, the Indian Constitution is referred to as the supreme law of the land. Because, why, the question is, why India's Constitution is referred as the supreme law of the land? That was the first point while we discussing the topic of India's Constitution. Right. So, that is the question. All the questions are not directly related with the paragraph, but it is connected in any way with the paragraph. But this is actually given in the paragraph. The Indian Constitution is referred to as the supreme law of the land because what? Is it because it is the oldest law in the world? Is this point correct? No, India's constitution is not oldest in the world. In India got constitution only in the year 1950. America, France and many other countries had constitution century before. So this is not actually correct, and it was the lengthiest written constitution of the world. That is actually point is correct, but is this the reason why India's constitution is called the supreme law of the land? No. All laws must conform to it. And the fourth point is, it was drafted by representatives of people. That is also correct, but the answer is this. Option C is the answer. Why India's constitution is known as the supreme law of the land? Because we have too many laws. All laws other than the constitution must conform or must work according to India's constitution. India's constitution is the basic or the supreme law, and every law should work according to or function according to India's constitution. Nothing contradictory to India's constitution can be run. If there is any contradiction with India's constitution by any other law, such contradiction or such laws to the extent of such a contradiction will become void, and which will prevail there. India's constitution will prevail because it is the basic law or supreme law of our country. So, all other laws must conform to according to India's constitution. That is why India's constitution is called the supreme law of our land. So, this is the answer. Hope you could get the answer. Next is, second question is, which of the following features does not form part of the Indian constitution? So, here actually the question is, which among the following is not a feature of India's constitution, or which among the following is not included in the India's constitution? In our constitution, we have a directive principle of state policy that is included in part 4. Supremacy of judiciary. Is there, have you studied something like that? Supremacy of judiciary. There is actually judiciary has certain powers, legislative has powers, executive has powers, but there is we have never studied about the supremacy of any judiciary. So, that's not a feature of India's constitution. The rest of the things are features. Fundamental duties is included in part 4A. Parliamentary form of government. India follow parliamentary form of government that we actually borrowed from the constitution of Britain. So, here the answer is does not form the part of constitution means supremacy of judiciary is the answer. So, that was the second question. And our third question is, why is November 26 as celebrated as Constitution Day in India? So, what is so peculiar about November 26? Why that November 26 is known as the Constitution Day in India? Let's look into the options. November 26, it marks the ends of British rule. The Constitution was adopted on this day. India's Constitution came into effect on this day. Drafting committee was formed on this date. Why? It marks the end of British rule. When the British rule actually ended, it was on 1947 August 15, not on November 26. Then Constitution was adopted on this date. Yes, correct. This is the answer. Constitution was adopted on November 26, 1949. To remember that day, November 26 is celebrated as Constitution Day in India. Then we can look into other options also. India's constitution came into effect on this date. No, India's constitution came into effect on January 26, 1950, right? Yes. Drafting committee was formed. When the drafting committee was formed, it was on 1947, August 29, right? Yes. So the answer is option B. Then fourth question is, why was the date January 26, 1950 chosen as the constitution, chosen as the day the constitution came into force? Also, it was adopted on November 26, 1949. The question, they are asking in the question like, India's constitution was adopted by the Constituent Assembly on November 26, 1949. Then why they choose the date of 1950 January 26 for the enforcement of India's constitution? That is the question. Why that date was chosen? So let's look into the options. To synchronize with the Republic Day of the United Kingdom. United Kingdom, something related to the Republic Day of United Kingdom. Is it the answer? No. To mark the end of World War II. World War II actually ended on 1945, right? Third option is to commemorate or to remember the 1930 Purna Swaraj resolution adopted by Indian National Congress. And the fourth one is as per instructions from Lord Mountbatten. So here our answer is what? Yes, option C is our answer. It was to commemorate the date of 1930 January 26. That was actually fixed or decided as the Purna Swaraj Day by the International Congress, Lahore session of International Congress held on December 1929. They decided to celebrate January 26 of 1930 as Purna Swaraj Day, complete independent day. But we could not achieve freedom from Britain on that date. So we had to wait 17 more years for that. So to remember that, to commemorate that date, we decided the enforcement of our constitution on 1930 January 26. So option C is the answer. So the fifth question, the last question from this paragraph. Which of the following shows the correct chronological sequence of the events related to the making of the constitution? So we had to know the years of all these events, then only we can answer this question. Actually the paragraph included this year, some of the years. August offer, that was an offer given by British Parliament to Indians. That was actually happened in the year 1940. Formation of the drafting committee. You all know we studied it today, 1946, right? Formation of drafting committee. Cabinet mission plan. Cabinet mission plan also came into India in the year 1946. So 2 and 3 are 1946. So formation of the drafting committee was in now December of 1946. We have to look into months now. Cabinet mission plan was came in May or something like that. So after cabinet mission plan, the drafting committee was formed. You all know. Formation of drafting committee was as part of the report of the cabinet mission. So first cabinet mission, after that formation of drafting committee. Then fourth point is constitution was adopted. That was on 1950. So first, what happened first? First August offer. First August offer. Second what? Second cabinet mission. Second cabinet mission. This is the second one. Yes. Cabinet mission. Second. Then thirdly what happened? Thirdly formation of drafting committee. This is third one. So here, and last constitution was adopted. So this is the answer. Option B is the answer. Hope you all got the answer. So these are the 5 questions took from that or related to the paragraph I have given. Actually these kinds of questions are asked in our CLAT examination. Some question may be directly taken from the paragraphs, or some question may be not direct but something related to paragraph that we can answer only if we have depth knowledge in the subject only. So, this paragraph is given as a model to your examination. So, let's move to the second paragraph. Yes, the second paragraph is, you can read with me. The Constitution of India is one of the most comprehensive and well drafted in spite of its elephantine size. Our Constitution represents a summit of consensus in India's political history. It manifests the best in our past traditions. It provides a considered response to the needs and aspirations of the present and possesses sufficient flexibility to handle and weather the requirements of the future. It is an instrument drawn with such a meticulously care by remarkable wise, articulate and erudite pantheon of persons of understanding abilities and backgrounds who so well understood how to make language fit their thought and vision. The Constituent Assembly met for the first time on December 9, 1946. The inaugural session was presided over by Dr. Sachinanda Sinha as provisional chairman. He was an eminent legal scholar as also a consummate advocate. This paragraph is actually extracted from a commemorative remembrance and tribute written by V. Sudesh Pai, published in Live Law. Okay, hope you all read the paragraph. It's very simple. The questions arise from this are, first question, that is the sixth according to first paragraph. So, first question is, which among the following led to the formation of the Constituent Assembly? So, which among the following is led to the formation of Constituent Assembly? Is it Government of India Act 1935 or Cabinet Mission Plan of 1946, then Independence Act of 1947, August Offer of 1940? What led to the formation of Constituent Assembly? We have already discussed the point. That is, Cabinet Mission Plan of 1946 led to the formation of a Constituent Assembly in India. Okay, next question is, who presided over the inaugural session of the Constituent Assembly of India? Who presided over the inaugural means first session of the Constituent Assembly of India? Yes, is it Dr. B.R. Ambedkar, Rajendra Prasad, Jawaharlal Nehru or Dr. Sachinanda Sinha? The answer is, as all of you know, Dr. Sachinanda Sinha. He was the provisional chairman of the assembly. So, he presided over the inaugural session of the assembly. So, he is known as the temporary or provisional chairman of the Constituent Assembly on the meeting held on December 9, 1946. So, he presided over or he chaired the inaugural session of the Constituent Assembly. Okay. Then the eighth question. So, an assertion and reason. We have to read it first. Assertion is, the Constitution of India is flexible enough to face future challenges. Constitution of India is flexible enough to face future challenges, and the reason given is, it was drafted by a group of wise and articulate individuals who understood how to translate vision into language. So, is the assertion is based on the reason, or is there any connection between the two, or that, or like that we have to assess. The first option is both the assertion and the reason are true and R is the correct explanation of A. Option B is both A and R are true but R is not the correct explanation of A. And C is A is true but R is false. D is A is false but R is true. So, we can look into the assertion and reason. Assertion is, Constitution of India is flexible enough to face future challenges. It is actually taken as given in the paragraph. Okay. So, it's same way it is given in the paragraph. So, it is true, Constitution of India is flexible enough. We have already studied that in our constitution or our India's constitution is both flexible and rigid. There is elements of flexibility and rigidity in our constitution. So, it is flexible enough. That means amendment can be made in the constitution to face the future challenges, because we have as of today we have 106 amendments in our constitution. That shows the flexibility of India's constitution. So, according to each time or the according to the needs of the time, India's constitution can be amended. So, that's actually meant by this assertion. And the reason is because it was drafted by a group of wise and articulate individuals who understood how to translate vision into language. So the constitution is that much flexible because it is by the future seeing vision of the by the makers of the constitution. So this is also true. This is the correct reason of the assertion. So the answer is both A and R are true, and R is the correct explanation of A. Okay, hope you understood this. So we are moving to the 9th question. 9th question is, who among the following was elected as a permanent chairman of the Constituent Assembly? Who was the permanent chairman, permanent president of the Constituent Assembly? And options are Sachidananda Sinha, Rajagopalachari, B.R. Ambedkar, Rajendra Prasad. And our answer is Dr. Rajendra Prasad. He was the permanent president or chairperson of the Constituent Assembly. He was elected as the permanent president on 11th December 1946 that we have already studied. And who was Dr. Sachidananda Sinha? He was the temporary president. Dr. B.R. Ambedkar is the father of India's constitution. Okay, we are moving to the 10th question. 10th question is, who described the Indian constitution as quasi-federal in nature? Who described India's constitution as quasi-federal in nature? This point we have already discussed while we took the introduction area. Is it Granville Austin, B.R. Ambedkar, K.C. Ware or D.D. Basu? Granville Austin called India's constitution as cooperative federalism. We have already told that. Now, quasi-federal nature, India's constitution was called as quasi-federal by K.C. Ware. Option C is the answer. So, these are the 5 questions related to the second paragraph. Okay, now I am moving to the third paragraph. This is the last paragraph for discussion for today. The paragraph is, you can read with me. For instance, the constitution borrowed the idea of directive principles from Ireland, the idea of fundamental duties from the Soviet Union. Large chunks of the constitution heavily borrowed from the Government of India Act 1935, the last constitution of the colonial India, which Ambedkar once described as a very powerful instrument which gave us a centralized government and a very big measure of provisional autonomy. Parts of the constitution had also been inspired by the constitutions across the globe. In 1946, the constitutional advisor to the Constituent Assembly, B.N. Rao, prepared a 115-page dossier for the drafting committee containing extract from the constitutions of several countries like Lithuania, Hungary, Peru, Syria, South Africa, Sweden, Switzerland, Canada and so on. The words equal protection of the laws in Article 14 were copied from the 14th Amendment to the US Constitution. In Article 19 Clause 2, the framers of India's Constitution decided to adopt the Irish example of setting out the exceptions to the freedom of speech and expressions in the text of the Constitution itself. The phrase procedure established by law in Article 21 was borrowed from Article 31 of the Japanese Constitution after a discussion Rao had with Justice Felix Frankfurter of the US Supreme Court. Extract taken from Why India's Constitution Still Thrives After 75 Years of Scrutiny, written by Abhinav Chandrachud, published in Indian Express. Okay, this is the last paragraph and you have to answer the following questions. And the 11th question is, from which country was the phrase equality before law in Article 14 of the Indian Constitution borrowed? Actually, in the paragraph we discussed about equal protection by the law, equal protection by the law we took from the American Constitution. Now, the question is, both equality before law and equal protection of law are part of rule of law in India. Concept of rule of law we actually took from British Constitution, and equality before law is actually is seen in Article 14, is took from the constitution of is UK, USA, Japan or Ireland. That's the question. Here the answer is UK itself. Equality before law took from UK. Equal protection of law, that we actually took from USA. These two principles are part of our rule of law in our country, and the rule of law principle actually we took from UK itself. Okay. So, option A is the answer. The 12th question is, who was the legal advisor of the Constituent Assembly? That's a very direct question. Who was the legal advisor of the Constituent Assembly? Is that Dr. B.R. Ambedkar, K. Munshi, B.N. Rao or Dr. Rajendra Prasad? The answer is exactly given in the paragraph, that is B.N. Rao. B.N. Rao was the legal advisor of Constituent Assembly. And the 13th question is, which of the following is not correctly matched? So, provisions are given in the first part, and secondly the countries from where such provisions taken. We had to find out which is the incorrect pair from these options. Rule of law. Just before we studied that rule of law, we actually took from United Kingdom. That is correct option. We had to find out the incorrectly matched item. So, office of the governor. As part of our introduction, we had told that office of the governor was actually took from the Government of India Act 1935. That's also correct. Concurrent list Ireland, fundamental duties USSR. So, fundamental duties are actually took from Soviet Union or USSR. That is correct. Then what is the incorrect match? That is option C. The concurrent list is not taken from Ireland. From where concurrent list taken? From Australia. It has been taken from Australia. Concurrent list was taken from Australia's constitution. So, that was the mismatched pair among the options. So, option C is the answer. And from Ireland, we took the directive principles of state policy and etc. And the 14th question is, which of the following countries influenced the concept of suspension of fundamental rights during emergency in the Indian Constitution? Which of the following countries influenced the concept of suspension of fundamental right during emergency? Whenever there is a national emergency, the fundamental rights of the people are automatically getting suspended is a provision included in India's constitution. According to, or the principle of that we actually took from the constitution of dash. Which constitution? Germany, Canada, United States, Switzerland. Yes, our answer is German or VMR constitution, VMR or German constitution. This principle is took from the constitution of German. Then emergency, if the question is like concept of emergency provision, if it is the concept of emergency provisions, the answer will be the Government of India Act of 1935. Now the question is not about emergency provisions but about the suspension of fundamental right during emergency. That's the German constitution. That's from the German constitution. And the last question for today's session is that question number 15. This is an assertion and reason. Assertion is, the Constitution of India provides for both flexibility and rigidity. Constitution of India provides for both flexibility and rigidity. That's correct. In Indian Constitution we can see both elements of, we already told about that. There is elements of flexibility and rigidity. The reason is that it can be amended by simple majority, special majority, depending on the type of amendment. Yes, India's constitution can be, some provisions can be amended very simply by simple majority, some needed special majority. So, that's depending upon the type of amendment and type of the provisions or the provisions, based on the provisions. So, the reason is also correct and the correct explanation of assertion. So, first option is the answer, both A and R are true and R is the correct explanation of A. So, that's only for today's class. We can hope we will have a next session in the coming days. Okay, thank you for watching. Bye.